the case for cooperation. This is an interesting topic in the area of e-discovery. There are, I would say, two of the most controversial words in e-discovery are proportionality and cooperation. And proportionality is a discussion for another day. Cooperation, though, is a hot button issue because there are still a significant number of attorneys, maybe even a majority, who believe that zealous advocacy means never cooperating with the other side, making the other side fight for every inch in the case. And that's always in the best interest of your client. And I'm going to show you today, we're going to talk about why that really isn't true anymore after the sort of rise of e-discovery. The scorched earth tactics that were pervasive for quite a long time now are actually counterproductive in a lot of litigation. So we're going to talk about that. But again, cooperation, surprisingly, is a hot button word in e-discovery. All right. First of all, the reasons why cooperation should be something that you're aware of, should try to engage in, is that it's required by the Federal Rules of Civil Procedure. The Federal Rule 1 was amended to specifically charge the parties with construing and administering the rules so as to secure a just, speedy, and inexpensive determination of their dispute. So using abusive discovery tactics to run up the cost of discovery, or making the opposing party fight for documents that are undisputably relevant, but requiring them to get a court order, those types of things are really violations of Federal Rule of Civil Procedure 1. And just some of the other rules that show you that the rules of civil procedure expect cooperation between the parties. 26A is initial disclosures. I mean, and under the federal rules at least, and we don't have those in state courts in Georgia, but under the federal rules, you are required to turn over at the outset of the case, without any discovery having been sent, the documents that you know to be relevant to your cause. Rule 26F has to do with the parties' discovery conference and discovery plan. It requires the parties to sit down and submit a joint plan to the court. And technically, that really should not be that hard to do. There may be one or two things that the parties can agree on, but most things at the outset of the case are typically easy to settle on. Anything that isn't, the parties could submit opposing plan, 26F plan, discovery plans to the court and let the court pick which one it wants. But that, I'll tell you, from a judge's perspective, that is a red flag if the parties are already disputing at the 26F stage. But sometimes it's appropriate. Depends on what the other side's asking for. 26G requires, basically says that the attorneys are required to sign any discovery disclosures, and when they do sign, they're certifying that the discovery is complete, consistent with the rules, and it's not interposed for any sort of improper purpose, really certifying that it's proportional to the needs of the case. And then Rule 37F is just a mechanism that the rules give the courts to sanction parties who fail to participate in the creation of a discovery plan under Rule 26. So the rules they tell you that there is some expectation of cooperation around discovery. Judges also expect cooperation. There is a document called the Cooperation Proclamation that was published by the Sedona Conference in late 2007, early 2008, I can't remember, but it is basically a document where the Sedona Conference says, look, because of the expense of e-discovery, we cannot continue to have this scorched earth litigation tactics and discovery, and here are some principles for cooperation that we endorse. Very general. Hundreds and hundreds of Georgia's judges have endorsed the Sedona Conference Cooperation Proclamation, and if you do a search on that document in Westlaw, you will see literally dozens of opinions citing that document specifically. So judges have a lot of ability to impose cooperation on the parties. Even the ones that don't specifically endorse the Sedona Conference, a lot of times will strongly encourage the parties to work it out amongst themselves before they get the court involved. And there's a lot of good reasons to do that. Quite frankly, a lot of times the parties should have a sense of how the judge is likely to rule, especially if you understand e-discovery and the rules around it. Why go and get an order when when it's going to be an adverse ruling for your client, if you believe it could be an adverse ruling for your client, it's in your interest to try to compromise on some points early on so that you don't upset the judge. You really want the judges to believe that the parties are able to work together reasonably and to cooperate. And quite frequently, when that's not happening, it turns into a war of emails between the lawyers trying to set the other side up, frame the other side to look like they're the unreasonable party, and the parties end up in court in front of the judge, making the judge read all of their emails over the past 2 months, pointing the finger back and forth, and it can get ugly. Most judges, even though you think you're right, the other side does too. In most cases, almost all cases, the judges will decide that both of you are wrong, and sometimes the repercussions of that were much worse than what you could have compromised on the other party with. Now, rules require it, judges require it. This is my soapbox moment. I believe that the profession is better when we cooperate. I can tell you that this is an adversarial career for the litigators, and it can grind you down. And quite frankly, the people sitting around you in your law school, some of them are going to be opposite you in a case. Some of they're people from other law firms, other law schools that are good people that you would like. And our profession used to be one that was very cordial. We can fight in court and argue till the cows come home, but then we should be able to leave court and be very professional and civil to each other. And it's not just that makes it's not going to make it will make your life better if you are cooperative. Reasonable is a very important word on that front, and not always trying to be difficult and make everybody fight for every yard. Scorched earth tactics will earn you a bad reputation in the legal community, and that is not something that you want. But what I want to focus on here is the oath. For those of you who will be practicing in Georgia, you basically have to swear that you will truly and honestly, justly and uprightly conduct yourself as a member of the learned profession and in accordance with the Georgia Rules of Professional Conduct. And there are two of them in particular that are relevant here. Rule 3.3, duty of candor, and Rule 3.4, the duty of fairness to opposing party and counsel. The duty of candor is basically, and you guys know what that is. It's that you are certifying that you are going to be candid with the court. You're not going to try to hide information. You're not going to give false information. Rule 3.4, you don't hear cited quite as often, but it really does apply in the discovery sense. It basically provides that the parties cannot obstruct another party's access to evidence or to alter, destroy, or conceal evidence, and it's punishable by disbarment. And so really negative, hostile, adversarial discovery tactics are a violation of the rules of professional conduct in Georgia. And judges that are inclined to agree with the Sedona Conference's cooperation proclamation and sort of see the trend going that way, it may start to enforce some of those rules. Now, the one that's probably most important to you as if you're a civil lawyer is that your clients no longer afford the lack of cooperation in discovery. If you don't have clients, you don't have a career. And if your clients go bankrupt because of the way you conduct discovery, you won't be practicing very long. And the reason that discovery has become so expensive is just the deluge of information. And you can see some of the statistics here on the slide. 108.7 billion business emails per day. That was back in 2014. I'm certain that number has not gone down since then. Here's one that's just a nightmare. 80 trillion text messages per year. That one is definitely going up. Lots and lots of companies now are establishing internal text messaging systems for their employees, and it is a nightmare from a discovery perspective. The typical publicly traded company lawsuit involves 650,000 documents. Some of them a lot more, some of them a little bit less, but 650,000 documents, and the number of those documents that can be reviewed per hour is 50. So you can do the math on that. I mean, it is a substantial investment of money. And I've got a hypothetical to show you where we can look at that in a little bit more detail. So my hypothetical breach of contract case where the plaintiff alleges $300,000 in damages. The plaintiff requests any and all documents regarding the contract, and that's pretty typical, these very open-ended, very broad discovery document requests. The defendant goes and collects documents for the 5-year term of that contract. and it searches them using keywords related to the contract, and the search hits 50,000 documents. So this would be, I'd call it a small case. Some people would consider it sort of a medium-sized case in terms of number of documents, but these days this number of 50,000 is not uncommon at all. So let's look at what that would be. 50,000 documents divided by 50 documents per hour means it's going to take 1,000 hours of review time to review all of those documents. Okay. If you put in 8-hour days, solid reviewing for 8 hours, it will take you 125 days of review. Keep in mind that you've got 30 days to produce your document, so you can see there's a problem here. If you put 2 reviewers on it, you're still at 60 days. 4 reviewers is what it would take, and that would be just cutting it close. Quite frankly, for this size review, you would need at least 6 reviewers in order to get the document review done in time, and probably more just to be sure. Now, that comes with a cost. 1,000 hours of review at $200 an hour. I use 200 just because it's sort of a blended average if the partners or associates are working on it. You know, maybe it's 150, maybe it's 300. It depends on the level of attorney and your billing rates. But at $200 an hour, a good kind of midpoint, this review would cost $200,000 just to look at the documents. The claims in the case are only worth $300,000. So if you're the defendant in this case, you're looking at the prospect of paying $200,000, and if you lose, you're going to lose another $300,000. And this pushes a lot of settlements in some cases. This is why discovery is used as a weapon. E-discovery is being used as a weapon. Now, here's the sad part. Typically, in a document review collected in this way with just using search terms during a date range, 70%, sometimes 80% of those documents are completely irrelevant to the action. 35,000 of those documents had no bearing on the case and did not have to be reviewed. And we'll show you and talk about some technology to help eliminate some of that fluff. But that's the sad reality, is that most of that money was wasted. And how many of these documents do you think that you will actually use in trial of this case? Maybe 100. It's very unusual for cases to have more than 100 exhibits. Quite frankly, the jury can't process thousands upon thousands of pages of documents. They won't remember. There's probably, out of this 50,000 documents, maybe 100 will find their way to court, and yet it costs you, really at the end of the day, because there are other components to this, more than $200,000, probably more than the value of the case, in order to get down to those 100 documents. So clients are looking for ways to change this paradigm. And cooperation is one of the tools. It is really the best tool that lawyers can use to limit discovery. So we're going to look at some opportunities and talk about some opportunities to cooperate within the course of your litigation. And when I say I've got it up here, while advancing your client's interest, again, adversarial, being a zealous advocate for your client you absolutely should be a zealous advocate. But being a zealous advocate is not the same thing as being a zealous adversary. And as we go through, we're going to find ways that you can protect your client's interest while saving them lots of money and still getting to the core, getting to the truth of the matter as best you can under the evidence. And that's really your charge. Opportunity 1, right at the outset of the case, scope of discovery and preservation. We talked about this a little bit in the rules. Really the key at the beginning of the case for cooperation is to learn about your client's data. Because the more information that you have, the more you know what their interests are going to be. And when you start negotiating agreements and limitations with the other side, you make limitations that are meaningful to your client, that will save your client money. So identifying the issues on which discovery is needed. Sometimes, if you've got a reasonable opposing counsel, if you guys are not at each other's throat right at the outset, and usually you aren't at the beginning of the case, what can you agree on? You're not going to agree on everything. You never will. But there are some things in a breach of contract case, for instance, all drafts of the contract are relevant. You'd be crazy to argue that they weren't. And so there are certain areas that you can agree on. Identifying the types of documents at issue, whether or not metadata is needed, go ahead and get these things resolved up front. A lot of times the parties don't know the cases yet, but you can generally know on the type of case what types of documents are going to be relevant to that case. Excel spreadsheets, emails, almost always, Word documents, but you may not need payroll stubs if the case doesn't involve anything to do with payroll. So get some agreement on what we're going to be looking for in discovery. Relevant date ranges, again, typically an easy one to agree on. There's some case law out there where the judges just seem baffled that the parties can't even agree on relevant date ranges. Date range is a great way to limit the scope of discovery, but you have to keep in mind at this point, there's a party on the other side who has a different range, and the idea is to try to find something that you can agree on. If there's not complete agreement, I'm going to talk about in a minute sort of how you can get around that at the outset of the case. But identifying accessible information repositories, why is that one in there twice? Oh, inaccessible, right? Accessible versus inaccessible. Particularly if you've got a database, let's say you've got a computer system, an old computer system where you used to keep customer data in a database that you don't use anymore, no access to it, it would cost a lot of money. Put that out up front. Say, look, that data is very difficult for us to get at. It's going to be incredibly expensive, and we don't intend to produce it unless it looks like there's no other way to get this information. See if the parties will agree to that. Identifying key custodians. Generally, there's some room for agreement there. Third parties and known complications, crash computers, legacy hardware, so on and so forth. You can't make agreements to limit the scope of discovery unless you know from your client answers to these questions. So you have to invest a little bit of time up front to get to know your client's data. So talking to in-house counsel or to the president, CEO, or to the IT director, understanding what type of data they have, where do they have it, is there anything that they really don't want to get into because of expense? These types of things will allow you to negotiate a good compromise for your client. So a little bit more for that. Look for common ground on the scope of preservation early in the case. A lot of times, if we have, if we think there's a date range that the parties should be able to agree to, we'll make it very clear, very express up front. Look, we're going to preserve documents in this date range only. And if the other side doesn't like it, typically, if you've been reasonable with your date range, they should agree. If they don't, and some won't, at least you're going to put it on them to go to the court and try to get a ruling contrary to your position early in the case before you've kind of gotten down the road and documents have been lost. And that reduces the risk of spoliation, which is really the club that they try to beat litigants with these days is, saying that documents were lost, they weren't preserved. And your position in that case would be, look, we agreed to preserve this date range and this date range only. The lost document was outside of that date range. You didn't object to it back then, so you're out of luck. And that's a winning argument 9 times out of 10. So getting early agreement on that issue, if you can, is very valuable to your client. And so there, again, identifying early areas of dispute allows for greater control and predictability in discovery. One thing that you're going to find, if you find yourself in a situation where you're representing corporate clients, sometimes more important to them in the case of being right and wrong is the budget. And the bigger your client, the more often that's the case. And being able to define the scope of discovery by agreement with the other side allows you to predict that cost. And predictability is incredibly valuable to your client, and they will thank you for it. Now, as I was saying, some of these issues, you may not be able to find absolute common ground with opposing party. Typically, agreements at this stage are made without prejudice to that party's rights to expand the limits as the evidence requires. And so what that means is that I will usually get the other side to agree, look, these 5 custodians were involved with this contract. They were the ones who were really responsible for the contract. Now, 40 employees at this company touched it at some way. They were involved in the actual contract, but it was these 5 people who were responsible for negotiating it, for agreeing to it. And so let's start with them. Let's do discovery on these 5. And if you don't find what you need, or if there's something in there that points to another custodian, then we will expand to that realm. Instead of asking us for any and all documents related to the contract up front, let's get any and all documents from these 5 custodians. And if we need to expand later, agree and make it be in writing, agree that you will agree to expand later if the evidence requires. Opportunity for cooperation, too, is document collection. And over-collection is a big problem. Parties that go out and collect any and all documents related to the subject matter of the case are going to come back with a heck of a lot of documents, and most of them are going to be really unresponsive or not important to the case. So trying to target your collection is a great way to reduce the cost and burden on your client. One of the ways to get the other side to agree to a more targeted collection is to exchange information. Say, these are the 5 most important custodians. We're going to go here. This is the date range where the activity in the case occurred. We're going to search these cases. Or this particular database or repository is where the relevant information is, so we're going to collect that first. That's called a targeted collection. It's really trying to get just what you need. The risk there is that you miss something because you don't know the case, as well as you'll know it at the end, at this stage. So, a lot of times there is an agreement. Look, if we find something in these targeted collections that suggests we should go out to another source, we'll do that. Sequenced or phased collections. This is something that is a great way to save money. It's something that is used by sort of more sophisticated e-discovery counsel, and I'd like to see, I think we will see more and more people using it. It's kind of what we just talked about. Phase 1, the red boxes you see there are the hot documents, documents that are really important to your case. And the blue documents are relevant, but they're not really important. They're not going to be trial exhibits. Somebody's talking about the contract, but they're not saying anything that important about it. In phase 1, the goal should be to hit the sweet spot. These are the 5 custodians. These are the 3 years that matter the most. Let's go in here and we're going to pull out, and you're going to get almost all of these documents. Now, as you review the documents in phase 1, you're probably going to see that one email with a particular conversation was forwarded to somebody who was not among those original 5 custodians. So in phase 2, the other side would come back and say, okay, give me all of that guy's emails now, or that lady's emails, because we didn't search them originally, and it looks like this person was involved. So phase 2, you're going to go out, and typically, if you're doing this right and you were honest and fair at phase 1, phase 2 will be a little less intrusive. It won't cost as much. It'll go faster. And again, you'll probably find a few more hot documents in phase 2. Phase 3, quite frankly, usually never happens. Most people after phase 2, sometimes after phase 1, say, you know what, I got what I need. I'm going to stop here, because it's incurring costs to their client as well. But it may be that in phase 1 or in phase 2 in particular, you stumble upon just a really important document that you have to have. And so the discovery requests for a phase 3 type of review is, please produce this document, and they name the document because they know what they're looking for, and so it's not incredibly burdensome or expensive. Phase 1 is, give me any and all. Phase 2 is, how about these custodians, or let's expand the date range a couple of months. Or here's a keyword that seems like it's important that we didn't use in phase 1, let's use it here. Phase 3 typically is, let's zero in on a document we've discovered or we believe exists. Now, the broader circle out on the outside, the preservation circle, I really just put this on here to show you that preservation is always going to be, or should be, much broader than the discovery sphere. And discovery isn't perfect. You'll see there's a relevant document out in the realm of preservation there that did not get produced in phase 1, phase 2, or phase 3, and that's okay. Document discovery is not expected to be perfect. The courts are very clear about that. If you've done a good job, there should not be any hot documents out there that got missed, but there might be a relevant document or 2 that did. So again, for phase discovery to work in this way, it really requires you to be knowledgeable and forthcoming in that initial phase 1, so that you and your client get the benefit of phasing the discovery. All right. Opportunity 3, data processing and hosting. And this one really requires some knowledge about how documents are managed once they come in-house. And some of you may have worked in a law firm and have seen this done. But basically, once the data is collected from the client, it's going to be processed for inclusion into some sort of document review software, unless it's a very small case and you're dealing with paper or a handful of PDFs. So in most instances, you've got lots and lots of documents, and you're going to port them into a document review platform. And the ways you can cooperate with opposing counsel on this side, this is very rarely done. I've done it in one case which is allowing the other parties in the case to share one e-discovery vendor, so that all of the parties' documents are being hosted in one database. And those databases can be partitioned so that the plaintiffs only see their documents and review them, the defendants see their documents and review them, and then when it comes time to produce, you push a button, and all of the documents that you intend to produce become visible to the other side, and vice versa. For smaller cases where the parties don't have a lot of money to spend on vendors, it's a way to sort of pool resources. So that, it requires a good deal of cooperation. For cases with lots of parties, and that's the scenario that we used it in, we had 6 or 7 parties, and instead of everybody paying their own vendor, we shared a vendor, we partitioned the database, and we were able to maximize some cost savings by doing it that way. This is pretty rare, but if you've got an attorney on the other side that knows e-discovery, that knows about partitioning, and the fact that this can be done in a way that, the fear is that the other side will see your documents because they're in the same database. There really is almost no chance of that, but so the people that are a little more experienced in e-discovery are more likely to agree to this type of thing. All right. Opportunity 4 for cooperation: document review. And this is the elephant in the room. Document review, as we showed before, in my hypothetical, is going to cost $200,000 because you're billing at some rate. If the attorney doing it, it's going to be $150, $200, $300 an hour. God forbid that a partner review documents at $600 an hour. 50 documents an hour, the cost goes up pretty quickly. So this is very expensive. A lot of people use contract reviewers. These are attorneys who either haven't gotten a job yet, or maybe they wanted some flexibility. They might be in the office all day. They want to be able to work from home. And they found this little niche practice of being a contract reviewer. And they come in and for $40 an hour, maybe $50 an hour, we'll review documents, and that's a huge cost savings to the client to do it that way. But document review is very expensive, very time-consuming. Some cooperative strategies for document review: agreeing to deduplication. Most document sets that you get are going to have lots and lots of duplicates. For example, if I email a copy of this contract to the guy down the hall, he's going to forward it on, or maybe I emailed it to 6 people, 2 of them forwarded it, and there are going to be dozens of copies of that contract on the system when it's all said and done. And depending on the needs of the case, generally, there's no reason to review all of them. It's redundant. It's a waste of time. And so with computer software, you can eliminate the duplicates so that you save cost. But you need to let the other side know that you're going to do that. And you can deduplicate globally, which means basically eliminating all of the duplicates within the entire data set, or you can do it by custodian. So that, if there's a duplicate document that custodian A had, that custodian B had, the fact that B also had a copy of that document might be important. So in that case, you wouldn't lose a production of that document from custodian B. And that's why you would do a deduplication by custodian if it's important to know who had it. And so but agreeing with the other side, getting them to agree to deduplication, most people will. Nobody really likes reviewing lots of redundant documents. Again, it's expense to review on both sides. Agreeing to email thread. Email threading is, again, a software tool that allows the computer to find these email chains, because typically, as you guys know, emails branch out. And email threading will pull together the most comprehensive thread of those chains, and that will be the only document that you review. Now, you can skewer off, and it doesn't mean that it's complete elimination of all threads, but the redundant threads are condensed into one email thread, and that, for big email productions, that's a huge time saver. It's going to save you time. It's going to save the other side time. Now, if there's an expense to it, and you do want to agree to it. The other side, if they get a production where there's just this one version of this email chain, but they can see it was copied to 8 people, and they don't want to know why you didn't produce, Susie Q's copy. The answer is, well, we threaded the emails. But so get agreement on that so that there's not some fighting, because people that don't understand e-discovery in particular may feel like you're somehow trying to hide the ball from them, which is not the case. And then the last one, agreeing to use technology-assisted review. Technology-assisted review is really a very general term. It encompasses predictive coding, language-based analytics. Sometimes it's graphical analytics in the case. There's all sorts of software that will analyze and allow you to sort and group documents, all of them collectively referred to as technology-assisted review. Most of the buzz in the e-discovery world is on predictive coding, which is really just a statistical-based computer algorithm that will find certain elements of a document that's been marked as relevant and will search the database for other similar patterns, or it's a pretty complicated algorithm, and it really is. A lot of people today are apprehensive of it because it's sort of a black box. Most people don't understand exactly what it's doing, and they think and they don't trust it. But it can save lots of money and time in the litigation because it basically ranks by relevance the document. So if you go into a data set and start out clicking documents as relevant, it's going to find other documents like those documents and move them up so that you get to review them first, which can save a lot of time and help you find the good stuff in your haystack. Puts all the needles at the top of the haystack, basically. So it's useful. But getting the other side to agree to it is almost essential. The thing is, when we were doing paper document discovery, the other side would send the request, and at the end of the day, they would get a production from us, and they had no idea what we looked at or which search terms we used, any of that stuff. But in e-discovery, that's changed. The courts have basically said, look, you've got to open up. There's got to be some transparency in the way that you're searching for and selecting these documents. So, I'm not suggesting that every court you come into is going to require you to show the other side your search terms. But I'll tell you, I found it to be very effective to get the other side to agree to some search terms very early on, because it limits the scope of the discovery. And if they agree to use certain terms and you use them, and they get what they asked for. I mean, it's not that. During the course of review, they may see some other documents that won't make them want to go back and expand it. But quite frankly, me deciding every single document relevant to this contract is a subjective opinion, and the other side may say, if we can agree on those search terms, we've got sort of a level playing field, and the other side can't complain. There's many, increasingly number of cases that are requiring the parties, particularly if they're using technology-assisted review, to disclose the methods that they're using to the other side. Document production. Document production is an area where there has to be some sort of agreement of the parties. You're really required to make this agreement early in the case. The way the rules are written, you can request documents in whatever format that you want. If you fail to request documents in a particular format, then the other side can produce it in the manner that they keep the documents, or in a manner that's at least as reasonably accessible as the way you keep it. So, but getting an agreement on it will avoid a lot of fighting and headache on this. So how does the other side want the documents produced? You should know that. You should get that ironed out at the 26F conference so that it goes into the discovery order, and the parties, there'll be no dispute about that later in the day. Where you see abuse of document production is that people will produce PDFs that aren't searchable of all of these documents. You can't keyword search them, and they're almost useless. They'll take thousands and thousands of documents and scan them as one PDF, which is very difficult to use as well. Or they'll take one multi-page document and scan it as multiple PDFs, and it's a nightmare, and it's abusive. And there are cases that will sanction for that type of conduct. But the way to avoid it is to get agreement and put it in your 26F. In cooperation, letting the other side know if you want metadata, letting them know what metadata you want. Don't insist on metadata from the other side unless it's actually something that you think is going to be relevant to your case. And don't resist producing it if the other side can articulate a theory of relevance that you think they're more likely to prevail on in court. Fighting over it, making them file motions is not the way to go. Your client will suffer from the additional cost. A lot of the cost of e-discovery is in filing and fighting over discovery motions. There was one case in your book that was a good example of that. It was the Western Convenience Stores versus Suncor Energy. And the court noted that the parties had filed 357 pages of briefs on a third-party subpoena, and the court said that if the council had extended even a fraction of that energy on working in a cooperative manner, the dispute could have been avoided. And that's the mindset that courts are going to look at this. And so avoiding unnecessary motions by not requesting metadata if you don't reasonably need it, and not refusing to produce it if it's clearly relevant. We talked a little bit about in the hypothetical how there was, depending on the number of reviewers you use, it could be very difficult to make your production deadline within the 30 days that you're allotted. So rolling productions is something that we agree to a lot with opposing counsel. We're going to produce weekly or we're going to produce monthly all the documents that we were able to review in that time period until we finish. And so even though it's going to be outside the 30 days, the other side's agreeing that's okay. Just give me what you got and let's do it on a rolling basis. And it's actually easier for the other side as well, something to agree to, because quite frankly, you get the documents in smaller chunks, and so that's easier for you to review what's being produced to you as well. So rolling production is pretty commonly used as a cooperation point. It prevents you from having to bring in 30 or 40 document reviewers to review big sums of documents in just a few days. Sequencing production to allow other discovery. This one's important. This is something that's sort of underused, but something to think about. If there's a long-term discovery with rolling productions, it may be that you're going to wait to do all of your depositions until all the documents have been produced and reviewed. It could be a year or more before you actually get into your depositions. And it might be in the interest of the case of the parties to say, we're going to produce all of the documents from custodian X, and then you can depose custodian X, and we'll keep rolling. Then we're going to produce from another custodian, and then you can depose them. And that has been used with a great deal of effect as a way to keep discovery moving instead of making all depositions wait until all document review is done. If you've got a lot of documents, and particularly if there are multiple issues and certain witnesses are really only relevant to some issues, you can sequence those productions to allow discovery to continue on those issues while review and production continues on other issues. And then opportunity 6 for cooperation, sort of the last one, but in large document cases, privlogs are incredibly burdensome. You have to record enough information about those documents for the other side to determine whether or not the privilege actually exists. And there's lots of documents to review. You create this big log that takes hours and hours and hours, sometimes thousands of hours to create. Some cooperative strategies for reducing the burden and delay, agreeing that you don't have to log every single time that outside counsel emailed the client, because that's clearly attorney-client privileged, and there's very little chance that that privilege is going to be cracked. So just agree that those correspondence don't have to be logged. Agree to allow batched or bulk logging for certain types of communication, and that's a little more controversial, but if you've got a really big body of documents, particularly in big corporations, you can say, look, we're going to batch all of our communications with our inside counsel as privileged, and just going to tag, instead of going through making an individual entry for every single one of them, we're just going to bulk tag those as privileged. That's a great way to save some cost. And then consenting to a Federal Rule of Evidence 502 order, the clawback. And that allows you, in cases where you get push comes to shove and you need to produce documents, that you don't have to worry about waiving the privilege. If you inadvertently produce a privileged document in that set, that you can get it back without waiver of the privilege. So that's another sort of privlog production strategy for cooperation. So that's, in a nutshell, I would say that there is no absolute agreement as to what constitutes cooperation. Professor Corkin and I were on a brainstorming committee with the Sedona Conference on looking at ways to improve cooperation, because since the Sedona Conference Cooperation Proclamation has come out, there's been some improvement, and the courts are driving it, but there hasn't been as much improvement as Sedona Conference would like. And so we were tasked with trying to figure out ways to get the word out on cooperation. And even within our committee, there was very little agreement about what it means to cooperate. And my advice to you as you go into practice is to view it from the perspective of what's important to your client. You really still are charged with protecting your client's interest. And now that doesn't mean you can violate your oath to the court or the rules of procedure, but you do need to think of it. And more, your client's interests are in not spending vast sums of money on discovery. So, but talk with your client, figure out what their interests are, try to find agreements with the other side that will help save. And if you've got a party on the other side who just refuses to cooperate and they're determined to do scorched earth, run up the cost, you've got weapons now to go to the court and to seek some relief. There's enough cases out there, like some of them in the book, where you can seek relief from the court from people that are refusing to cooperate. I do think that the tide is turning on cooperation, and it's just a matter of being committed to it and doing it in a way that doesn't impair your client's rights. So that's it for the lecture today. I will try to get this posted. I had some technical difficulties last time, and I ended up posting on YouTube, but I think I stripped all the pictures and color out of this one in order to, maybe that'll help it upload a little bit better. So if you have any questions, again, please feel free to email me. Thanks a lot. Have a good weekend.